My name is Lena Vasic. I am 29 years old. And the Thanksgiving evening my parents announced they were removing me from the family trust in front of 8 people was the night I finally understood that the family story and the legal record are two entirely different documents. They did it between the soup and the main course. My father stood up, which he rarely did at the dinner table, and said that he and my mother had made a decision about the estate plan and wanted the family to hear it together. My mother had her hands folded on the tablecloth. My brother Darius, who is 4 years older than me and has lived 6 miles from my parents his entire adult life, was sitting across from me with the expression of a person who already knows what the announcement is. Lena has not shown the commitment this family requires, my father said. He did not look at me while he said it. We've made adjustments to reflect that. You have contributed nothing to this family, my mother added. Her voice had the quality of something that had been prepared in advance and was now being delivered on schedule. Darius raised his glass. I reached for the salt shaker at the center of the table. I moved it 3 inches closer to my plate and set it down. I did not stand up. I did not push back my chair. I picked up my soup spoon and I returned to the soup. What none of them knew, what Darius did not know, what my parents with their prepared sentences did not know, was that the trust document they were describing had a second schedule attached to it. Schedule B. 4 pages, single-spaced, drafted by an estate attorney 3 years before that dinner. My parents had signed it. I had a copy in a file folder at the back of my desk drawer at home, and I had read it enough times that I could have recited the relevant paragraphs from memory. I had not done anything with it yet. I was waiting to understand what I was looking at. I was almost finished understanding. My family's version of me had been written early and revised rarely. I was the second child, born 4 years after Darius, in the specific position that family systems sometimes create for the one who arrives after the pattern is already set. Darius had been a gifted student, regional math competition, early admission to a good university, the kind of academic record that families point to when they are explaining themselves to other families. He had gone into commercial finance and done well at it, in the way that people do well when the right opportunities arrive at the right intervals and they are positioned to receive them. He had come back to the city where our parents lived and had bought a house 12 minutes away and had dinner with them most Sunday evenings and was, in the private language of our family, the successful one. I had been the one who took longer. I had not struggled academically. My grades were good. My teachers generally found me capable. I had been admitted to the university I applied to without difficulty. What I had done was take a less legible path. I had studied environmental science, which my father understood to be a soft field with unclear professional applications. I had spent 2 years after graduation working for a regional land trust, cataloging habitat parcels and writing grant applications for a salary my parents considered insufficient evidence of seriousness. I had then gone back to school part-time for a master's degree in ecological restoration while continuing to work, which had stretched the process over 4 years and had given my family, during that period, a sustained opportunity to use the phrase "still working on her degree" in social contexts where it carried the implication they intended. I had completed the degree 18 months before the Thanksgiving dinner. My parents had come to the hooding ceremony. My father had taken a photograph that I did not ask him to take, and my mother had said she was proud of me, which I believed she meant, and which I also understood was a different thing from believing the degree would change the family's working assessment of my trajectory. It had not changed it. What the degree had done was get me hired, 6 months after completion, as a junior restoration ecologist at a federal agency, a position that required the credential I had just earned, and that came with a salary, benefits, and the kind of institutional standing that does not announce itself in family conversations, but that exists in the public record for anyone who chooses to look. My parents had not chosen to look. What they knew about my job was that it involved fieldwork and government employment and a salary that was lower than Darius's, and they had filed it under the same category as the land trust years. Useful, perhaps, for someone without better options, not a marker of direction. I had been at the federal agency for 14 months by the time of the Thanksgiving dinner. I had not told my parents about the project I had been working on for the previous 7 of those months. The project was a reason I had not had time to explain it, and another reason I had not been certain until recently what it would amount to, and a third reason that I will come to. The trust had been established 8 years earlier, when my father had turned 60 and an estate attorney had advised him to begin organizing the family's assets in a structured way. The family's assets were not extraordinary: a house worth approximately $740,000 in the current market, a portfolio of retirement accounts, a small rental property that had been in my mother's family, and that generated modest income. The trust was designed to hold these assets and distribute them according to a schedule that my parents and the attorney had worked out over 2 meetings. The attorney's name was Harriet Vance. She was a methodical woman who had been doing estate work for 26 years and who, I would later come to understand, was meticulous about documentation in ways that not all attorneys are, and that my parents, who were not close readers of legal documents, had not fully appreciated at the time. The trust had 2 schedules. Schedule A described the primary distribution, the house, the retirement accounts, the rental property, and how they would be handled after both of my parents were gone. It named Darius and me as equal beneficiaries. My parents were aware of this and had discussed it with the attorney. Schedule B was a provision Harriet Vance had included at my father's initial instruction and then, apparently, set aside when the conversation moved on. It described a mechanism for modifying the distribution based on documented contributions to the family's financial stability. My father had mentioned, at the first meeting, that he wanted the trust to reflect the reality of who had carried the weight of the family over time. Harriet had drafted a schedule that operationalized this concept. Contributions to mortgage payments, household maintenance costs, and direct financial support to either parent during a defined period would be tracked and weighted against the base distribution. My father had signed Schedule B along with everything else. I do not think he read it carefully. I think he understood it as a general statement of principle, a way of encoding the family's values into a legal document, and did not examine the mechanism by which those values would be measured. The mechanism was specific, detailed, and documented. 3 years before the Thanksgiving dinner, I had found a copy of the trust document in a file my mother had left out during a visit. She had been organizing paperwork and had stepped away from the table, and I had read what was in front of me the way I read everything, which is to say carefully and completely. I had read Schedule B twice. I had taken a photograph of the relevant pages with my phone before my mother came back to the table. I had not told anyone what I had read. I had spent 3 years understanding what it meant. What it meant, as I came to understand over those 3 years, was this: the trust schedule B created a formal mechanism for recognizing contributions that the family's informal accounting had never captured. Harriet Vance had defined contributions broadly and specifically at the same time, broadly in that they included non-financial forms of support, care provided during illness, professional services rendered at below market rate, and specifically in that each category required documentation, receipts, correspondence, records of time. The kind of evidence that exists in the world, quietly, when the person who created it had the habit of keeping records. I had the habit of keeping records. I had developed it not strategically but professionally. Environmental fieldwork runs on documentation, chain of custody, dated observation logs. I had carried the practice into my personal life without thinking much about it. What I had, by the time of the Thanksgiving dinner, in the file folder at the back of my desk drawer, receipts for $4,300 in grocery and household supply runs for my parents over a 3-year period during which my mother's mobility had been limited by a knee replacement and recovery, a copy of my father's medication management spreadsheet, which I had built and maintained for 14 months when he was adjusting prescriptions after a cardiac event, 11 months of correspondence documenting the coordination I had done between my parents and their various service providers, the contractor who had repaired the rental property's roof, the accountant who had filed their taxes the year my father was in recovery, the insurance adjuster who had processed the claim, and, more recently, 7 months of documentation relating to the federal project. The federal project was a habitat restoration assessment for a wetland parcel adjacent to a property my parents owned. Not the house, not the rental property, but a small land holding my mother had inherited from her father and that had sat on the county's books for 30 years as undeveloped rural land with no assessed value above nominal. My agency had been contracted to assess a corridor of wetland parcels in the region. My mother's parcel was in the corridor. I had disclosed the relationship to my supervisor, recused myself from the direct assessment, and watched as a colleague completed the evaluation. The colleague's assessment found that the parcel contained a category of protected wetland habitat that triggered a federal enhancement designation. The designation did not restrict my mother's ownership. What it did was make the parcel eligible for a conservation easement payment, a voluntary program through which the federal government compensates landowners for agreeing to maintain the parcel's ecological character in perpetuity. The payment schedule for parcels of this type and this designation in the region where my parents' land was located was $187,000. My parents did not know the parcel had been assessed. They did not know about the designation. They did not know about the easement program. They had not thought about the parcel in years. I had drafted an initial summary of the situation for my supervisor 7 months before the Thanksgiving dinner. I had been waiting for the formal designation to be finalized, a federal process with its own schedule, before deciding what to do with the information and how to present it to my family. The designation had been finalized 11 days before Thanksgiving. I had a copy of the finalization notice in my file folder. I had not yet decided when to show it to my parents. I had been planning to wait until after the holidays, when there would be time for a real conversation. Then my father stood up between the soup and the main course. I drove home from Thanksgiving dinner at 9:43. The drive was 40 minutes. I did not call anyone. I set the file folder on my kitchen table when I got home and sat down in front of it and spent an hour reading through the documents in the order they had accumulated: the grocery receipts, the medication spreadsheet, the contractor correspondence, the designation notice, and the 4 pages of Schedule B. The question I had been carrying for 3 years, "What do I do with this?" had resolved itself at the dinner table in a way I had not anticipated. Not because I had decided to act, but because I understood, sitting in front of the file folder at 10:30 on a Thursday night, that the decision had already been made. The document existed. The contributions existed. The designation existed. These were facts in the world, and they were going to remain facts in the world regardless of what I decided to do about them. I called an estate attorney the following Monday. Her name was Patricia Kwan. I had found her through the agency's Employee Legal Assistance Program, which provided referrals and initial consultations at no cost for employees who needed legal guidance. Patricia was 44 years old, had been doing estate and trust litigation for 15 years, and had the manner of someone who has read every variety of family document and has stopped being surprised by any of them. I sent her the file folder contents, digitized, the night before our first meeting. When I arrived at her office, she had a printed copy of Schedule B on the desk in front of her with annotations in red pen. "Your parents signed this," she said. "Yes. And the contributions you've documented fall within the defined categories." "I believe so." She looked at her notes. "The wetland parcel designation, that's separate from the trust. That's your mother's asset. But it's relevant to the contribution analysis because your professional work created the condition that made the designation possible, even though you recused from the direct assessment." "Yes. That's a more complex argument than the documentation of direct support," she said. "I'd want to be careful about how we frame it. But the direct support documentation is clean." She set down her pen. "How would you like to proceed?" "I'd like to understand my options," I said. "I'm not interested in a fight. I'm interested in an accurate record." She looked at me for a moment. "Those two things are not always the same conversation," she said. "I know," I said. "But I'd like to try to make them the same one." Patricia reached out to my parents' attorney 3 weeks after our first meeting. She had drafted a formal notice under Schedule B's documentation provision, a procedural step that the schedule itself required before any modification could be considered. The notice described the categories of contribution, attached the supporting documentation, and requested a response within 30 days. My parents' attorney was a man named Robert Elias who had handled their affairs for 12 years and who, Patricia told me after their first call, had not been aware that Schedule B existed in its current form. He had been present at the trust signing but had not drafted the document. Harriet Vance had been the drafting attorney, and he had apparently never examined Schedule B closely enough to understand the mechanism it created. His response, when it came, was that my parents disputed the characterization of my contributions and intended to contest the notice. The formal language was precise and non-personal. Patricia had expected it. This is the part that will take time, she told me. They're not going to agree to modify the distribution informally. We'll need to go through the court's trust administration process. How long? 4 to 6 months if it stays procedural. Longer if they contest aggressively. What's your read? She was quiet for a moment. Your father's attorney knows Schedule B is enforceable, she said. What he doesn't know yet is how strong your documentation is. Once he sees the full file, his advice to your parents is going to change. She was right. It took 8 weeks. The full documentation file went to Robert Elias's office on a Tuesday in January. On the following Thursday, Patricia received a call from him. He had reviewed the materials and wanted to discuss a potential resolution. The call lasted 40 minutes. Patricia relayed its contents to me that evening. Elias had advised my parents that the documentation was sufficient to support a Schedule B modification, that contesting the notice through the court process carried a meaningful risk of a less favorable outcome than a negotiated resolution, and that he recommended they consider the negotiated path. My parents had asked for 2 weeks to think about it. The meeting happened on the last Thursday of February, at Patricia's office. My parents arrived with Robert Elias. I arrived with Patricia. My mother was wearing the coat she wore to formal appointments, the navy one with the gold buttons that I had seen at school events and medical consultations, and the one funeral I could remember attending with her. My father looked the way he looked when he was managing something he had not planned for, contained, precise, slightly compressed. Patricia walked through the schedule analysis first, the documented contributions, the categories, the evidentiary standard. Robert Elias raised 2 technical objections, both of which Patricia had anticipated and addressed in a supplemental memo she had prepared the previous week. The objections were procedural rather than substantive. After 30 minutes, the procedural discussion was finished. My father looked across the table. The grocery receipts, he said. The medication spreadsheet. I didn't realize you'd kept all of that. I keep records of most things, I said. It's professional habit. He was quiet. I'm not asking you to renegotiate the whole trust, I said. I'm asking for the schedule to reflect what actually happened. My mother looked at the papers in front of her. Her hands were still. The parcel, she said. You said Lena found the designation. Her professional work identified the habitat category, Patricia said. She recused from the direct assessment. But the chain of discovery runs through her. That's worth $187,000, my mother said. It was not a question. That's the current program rate for parcels of this designation in this region, Patricia said. Your family will receive that payment when you execute the easement agreement. That's separate from the trust proceeding. My mother looked at the table for a moment. Then she looked at me. The look had a quality I had not seen from her in a long time, not warm, not apologetic, something more precise than either. It was the look of a person updating a ledger. We didn't know about the parcel, she said. I know. I was going to tell you after the holidays. Then the dinner changed the timing. She was quiet. My father picked up his water glass and set it down without drinking. Robert Elias leaned toward my father and said something in a low voice. My father nodded once. We'll accept the schedule modification, my father said. Patricia has the proposed distribution adjustment. She does, I said. The paperwork was signed that day. Patricia filed the modification with the court the following Tuesday, as the schedule's procedural requirements dictated. The filing was a matter of public record. A judge reviewed the documentation and the signed modification agreement and entered an order confirming the Schedule B adjustment at a brief hearing 3 weeks later. My parents were not present at the hearing. Robert Elias appeared on their behalf. Patricia and I sat at the respondent's table and watched the judge review the file. The judge, a methodical woman in her late 50s named the Honorable Carol Desai, read the key provisions of Schedule B aloud for the record, including the paragraphs that described the contribution mechanism and the signatures below them. She asked Patricia 2 brief procedural questions, received 2 brief answers, and entered the order. The hearing lasted 11 minutes. I called Darius that evening. He answered on the 3rd ring with the careful neutrality of someone who has been briefed on a situation and is waiting to find out which version of it he is about to receive. I told him what had happened, the schedule, the documentation, the modification, the hearing. I did not editorialize. I went through it in the order it had occurred, the way I would describe a field assessment. What existed, what I found, what the process produced. He was quiet for a long moment after I finished. Then, the parcel. Yes. You found that. My agency assessed the corridor. I recused from the direct work. But yes. Another pause. Mom and Dad are going to get $187,000 from it. When they execute the easement, yes. Patricia can connect them with the program coordinator. He was quiet again. Why didn't you say something? At Thanksgiving. Or before. The designation had just been finalized, I said. I was waiting for the right time. Then the dinner happened. You had the file folder with you that night.
No.
It was at home. I went back and looked at it after. A silence. Lena. He said my name with the particular weight of someone who is revising something they have held for a long time. I raised my glass. I know. I shouldn't have done that.
No.
Is there? He stopped. What do you want from me? I don't want anything specific, I said. I'd like us to have an honest accounting of what the last few years have actually looked like.
Not an argument about it.
Just an accurate picture. He was quiet for a moment. That's going to be a hard conversation. Probably, I said. But I think we can have it. My parents executed the conservation easement agreement 4 months after the February meeting. The payment, $187,000, arrived on a Wednesday in June, deposited directly to my mother's account. Patricia's office sent a confirming letter the same day. My mother called me that evening. It was a brief call. She said the payment had come through and that she wanted me to know she understood now what the parcel situation had represented. She said it without preamble or elaboration. I said I appreciated her telling me. We talked for another 12 minutes about unrelated things, the rental property's new tenant, a prescription adjustment my father was managing, the garden she had been putting in on the south side of the house. The conversation was ordinary in the way that ordinary conversations are when two people have recently finished a difficult one and are finding the shape of what comes next. I have been back for dinner 4 times since the February meeting. My mother cooks the same things she has always cooked. My father asks about my work with the same careful attention he brings to information he is genuinely trying to understand, which is a different quality than the attention he used to bring, and which I receive as the thing it is, without requiring it to be more. Darius and I had the honest accounting conversation I had described to him on the phone. It took 3 hours over 2 meetings at a coffee shop that was equidistant between our apartments. It was not comfortable. It was accurate, which was what I had asked for, and by the end of it we both had a clearer picture of the dynamic that had shaped the last decade of our family's life and our respective positions in it. He apologized for the glass. I told him that the glass had been a small thing in a long history of small things, and that I was more interested in the history than in the glass. He said that was fair. It was fair.
I meant it as such.
I still have the file folder. It lives in the same desk drawer where it has always been, behind the hanging files for utilities and insurance. The notarized letter of commendation is in it, a letter my supervisor had written 18 months before the Thanksgiving dinner, documenting my professional contributions to the corridor assessment project in the formal language that federal agencies use for such records. I had not submitted it as part of the Schedule B documentation. It was not necessary, and Patricia had advised me to use only what was directly relevant to the defined categories. But it is there, and it has been there, and it describes accurately what I did and when I did it and what it produced. I keep it for the same reason I keep all the records, not because I expect to need them. Because the work of building an accurate account of your own life is ongoing, and the materials for it accumulate in the ordinary course of doing things carefully, and it is better to have them and not need them than to need them and find out they were never kept. The easement is permanent. The parcel will remain as it is, the habitat intact, the water moving through it the way it has for longer than the family has existed, and that will be true regardless of what the family remembers or forgets about how the designation came to be. The land does not require anyone's acknowledgement to remain what it is. Neither I have come to understand, do I? The record is not a weapon. It is not a threat, and it is not a trophy. It is a description of what happened, and descriptions of what happened have a durability that no one's version of events can entirely override. I did the work. The work produced something. The document says so. Whether or not the room believes it, the document remains. You cannot unsign what you signed. There were two moments in this story where everything could have gone differently: when I reached for the salt at that Thanksgiving table, and when I called Patricia the following Monday instead of calling my parents. Which one do you think was harder, and why? Subscribe if this story stayed with you. A new one posts every week. If you made it to the end, like and hit the bell. It matters more than you know.